Your Money and Your Life podcasts by Mogers Drewett to help you navigate life's legal and financial challenges.
This short podcast series features 2 special episodes relating to parents with SEN children and raises some important questions relating to the long-term support for vulnerable children. In this, the second podcast, we focus on the importance of long-term planning for SEN children, specifically provision relating to the death of one or more parent. In particular, it discusses how setting up an appropriate structure via a special will or trust can ensure that your estate is left in the most appropriate and beneficial way to protect your SEN child and cater for their individual circumstances. My name is Anne-Marie Worth. I'm a solicitor at Mogers Drewett, specialising in wills, trusts, probate, court of protection work and later life issues. Nicola Setchell is an administrator at Mogers Drewett. She has a 14-year-old son with special educational needs. She is therefore asking these questions from a personal perspective, but she very much hopes that the issues discussed today will relate to other parents with SEN children.
Hi, Anne-Marie.
Hello there.
Back again. So today, I guess we're talking a little bit more about sort of future financial planning. It's quite a difficult one, this one. As a parent of a SEN child, you quite often feel like you need to live forever because nobody is ever going to be quite as good as you at looking after your child. But, you know, reality, we are all going to have to leave this mortal coil at some point. Making a will is, a big sort of step that we all have to consider. Perhaps we could start today by just discussing very quickly what a will is and what it actually does.
Sure, yes. So a will is a legal document that takes effect on your death. There are certain legal formalities that need to be complied with to ensure that the will is valid. So I think it's really important that you take professional advice when setting up a will, particularly if you have unusual circumstances that does require some certain advice to ensure that the will is appropriate for your circumstances. I would just sort of mention here that a will shouldn't be confused with a lasting power of attorney. It may be obvious to some people, but some people do actually confuse the two. A lasting power of attorney is a lifetime document that takes effect whilst someone is alive and allows you to make decisions on someone's behalf whilst they're alive. The power stops on death, and that's when the will kicks into effect. So the will takes effect when someone dies.
And what does it allow you to do?
So a will allows you to appoint executors. It allows you to appoint guardians if you have children. And generally speaking, it allows you to leave your estate in the way you want to leave your estate. So particularly with SEN children, I think this is very important, because if you don't make a will, then the intestacy rules apply, and those rules are not necessarily going to cater for your needs. Mm-hmm. I think for parents with SEN children, that there are certain things you do need to consider. And those are the appointments that you make. So appointments of executor and trustee are very important, particularly if you're making a special will, which includes a trust to cater for your child. You know, those people that you appoint are going to be trusted people with the relevant knowledge and capability that you need for them to carry out that role. Executors and trustees don't have to be the same people, but quite often they are. I think guardianship is also quite an important thing for a parent to consider. I think parents with any children, it is important, isn't it? Because if both parents die whilst the child or children are under 18, then you can appoint a guardian to care for the child until they reach 18. But particularly with a child with certain special educational needs or other needs, then the appointment of guardianship, I think, is that much more important. And you can set out a side letter of wishes to give more specific guidance to the guardians on what they need to consider when bringing up your children. The interaction between trustees and guardians is also quite important. Quite often they're two different people to avoid a conflict of interest arising, but it's really good to think about who those people are going to be and discuss that with them, obviously, prior to getting your will set up. Obviously, leaving your estate, if you have a SEN child, and really thinking about how you're going to provide for your children is really, really important. So think about your child's situation. Do they have capacity to be able to receive funds? Absolutely. Do you need to think about a trust as a structure to look after your SEN child's share? And are they in receipt of welfare benefits? All those things. And then really go and get that professional advice to set up the best will that is possible in your situation.
Yeah, really tough questions actually to think about as a parent. But what are the legal implications if you don't have a will? What would happen then?
So if you didn't have a will at all, then the intestacy rules would apply. So the law states what happens. The law states who deals with your estate and who receives it. And, quite often that's not in accordance with your wishes. So there are just a couple of things to mention here that, if you have a spouse, some people think that all of your estate passes to your spouse. If you have children, that's not necessarily the case. If you have an estate of a certain wealth, if you have a certain wealth, then only the first proportion of your estate goes to your spouse, and the remaining share goes to your children, absolutely in equal shares. If you are, say, a sole parent, you don't have a spouse, and then everything will just pass to your children in equal shares. Now, whilst that might be appropriate for some people, if you have a SEN child, then that may not be appropriate at all, and actually may be disastrous. If your SEN child is receiving welfare benefits or government funding, and they suddenly receive this inheritance, then that may have adverse consequences for your welfare benefits, because if you receive capital of over 6,000, you have to declare that to the DWP, and that may well affect your state benefits. Also, if your child does not have mental capacity to look after these new funds that they receive, then that may trigger a deputyship application to the Court of Protection for a third party to look after those funds on the mentally incapacitated child's behalf. Whereas before receiving an inheritance, the deputyship application may not be needed at all. So really, really important to get a will in place in any situation, but particularly if you do have a SEN child.
Yeah, absolutely. So what's the procedure for setting one up?
So for setting up a will, we would be happy to take instructions, or happy to give initial guidance to new clients over the phone. And let them know what to expect and what the process will be, and give them some initial information that may help them. If they want to proceed, we would then set up a meeting to go through all the details of the will. We would take proper instructions and get all the details about their estate and their family situation, advise them on any tax implications that arise in their estate, and advise them on the best approach in relation to setting up a will, and the best structure that they should use. Once the client is happy with that, then a draft document will be prepared and sent to the client for approval. This normally will be a draft will, and also if there's a trust included, then a letter of wishes would normally go alongside the will. And that's quite an important document, because that sets out the specific details that the client really wants the trustees to consider when managing the trust. So that is very much a document that can be bespoke and worked on and perfected really in accordance with the client's situation. And once the client is happy with everything, then we'll make arrangements for them to sign the will. The whole process, again, would vary depending on the circumstances, the complexity of the instructions, and how quickly clients can sort of respond with information, that sort of thing. But I would say generally about 3 to 5 weeks for the whole process.
Yeah. And in terms of cost, what sort of cost would you be looking at?
Okay, so if we're talking about standard wills for couples without any sort of trust structure, so that's quite straightforward requirements, then we charge a fixed fee of £595 plus VAT. That's for couples or spouses to do mirror wills. For one single will, it's £395 plus VAT. But if we're talking about a more bespoke will, perhaps with a trust, which I keep sort of mentioning, which may well be an appropriate structure for leaving inheritance for a SEN child, then a trust will require more work inevitably, and so the cost will be higher. So for a sort of standard will trust for couples, our costs start at £900 plus VAT. And for more bespoke wills, which are slightly more complex, the cost would start at £1,200 plus VAT for mirror wills.
Yeah. Can a will be changed at any point?
So a will can absolutely be changed at any point, whilst a person has mental capacity to change their will, and before their death, obviously. So, Anna, we actually advise you to regularly review your will every few years, just to ensure that it is continually up to date and accounts for changing circumstances in your life. So once a will is done, then that will be your final will, but you can make amendments, and amendments can be made either way by a codicil, which changes makes small changes to your will. So if you just wanted, for example, to change an executor, a codicil might be the right thing to do. If you wanted to make more significant changes to your will, then a new will may suffice. And then when you sign the new will, that then supersedes the old will. But it's absolutely easy to do, much easier than with the LPA, the LPAs and deputyships.
Yeah, and I suppose it's something that you need to look at throughout your life as your circumstances change, more children come along, grandchildren, etc., etc.
Yeah, death of a beneficiary or an executor. Yes, particularly with anything significant, life-changing, then definitely come and review your will.
Yeah.
So just as important it is to make a will in the first place, it's really good to update your will, as I've said, but also there are certain events which may trigger you to think about updating your will. So if you get married and you already have a will in place, then the marriage will revoke the will that you have. So you will need to make and sign a new will after your marriage. Okay. And also divorce is another event that will trigger the need to change your will. So if you have a will in place and you get divorced, then what that will mean in terms of the legality of the will, it doesn't revoke the whole will, but it's treated as if your former spouse has predeceased you. So they will be eliminated from your will. And obviously, you will then need to make a new will, an updated will to cover your new circumstances.
Yeah, really good advice, thank you. Especially as I've read somewhere that a lot of families with SEN children are at a higher risk of divorce. So really good advice. What happens if, say, your spouse passes away? What would happen then?
Okay, well, that will all depend on what's written in your will in the first place. So if I have made wills for couples or spouses, then we would normally deal with that and account for that in the original wills. So typically, wills would be left to each other for spouses, and then on the second death, so when the second spouse dies, then your joint estates is then left to your children, and then perhaps if you have a SEN child, that trust structure that you've perhaps put in takes effect on the second death. So normally you would include the two scenarios when one spouse dies and then the second spouse dies. However, it's really good in any event to review your will if a spouse dies, because obviously that's quite a significant event, just to ensure that the will is still valid and it doesn't need changing in any way.
Yeah, great. So my in-laws, they've asked for some advice in relation to leaving my son some money on their death. Have you got any advice for, say, grandparents who want to leave money and what they should do?
Yes, it's a really good question, because if a relative leaves money to a SEN child in a will, that might not necessarily be an advantageous thing to do, because of issues that I've just discussed before relating to their welfare benefits and affecting those that income that they're receiving. So I think it's a really good idea for a relative who's intending to make a will to leave money for your child, to discuss that with the parents. So discuss that with you and just discuss what is probably the best approach in this situation. Just check whether the person, the child has mental capacity, whether they do have welfare benefits, and whether there is some sort of other way that they can leave their inheritance to the child without affecting their benefits. So if there is already a trust in place, and it may well be that the parents or other family member have set up a trust during their lifetime for the disabled child, which is already designed to cater for their situation, and it doesn't have any adverse tax or other consequences. So the relative could leave the money intended for the child into that trust instead of to the child outright. So that's a really good way of actually providing for the child if there is already a suitable structure set up. But certainly, speak to the parents, but also take legal advice themselves, and a professional advisor can talk them through the best way of doing that.
Yeah, great. So, I mean, you've mentioned trusts quite a lot already, but perhaps could you just maybe tell us a little bit more about them?
Yeah, so I have mentioned that because if we're talking about a child who has a disability or autism, or and is unable to manage their own finances, then, as I keep saying, it's not going to necessarily be a good idea to leave the money outright. So ordinarily, if you set up a trust in the will or during your lifetime, because you can do either, and both, and a lifetime trust actually may be just as beneficial, if not more, than setting up a will trust. Ordinarily, a trust can have quite adverse tax consequences, but there are special types of trust for vulnerable people, sometimes known as disabled persons trusts, which cater for this very situation. So the usual tax rules don't apply, and it enables money to be placed in that trust, and any money paid from that trust on the benefit on behalf of the mentally incapacitated child does not affect their means tested benefits and has special tax treatment. So therefore, it can be a really good way of protecting the SEN child and ensuring that it enhances their quality of life. So as I said before, you can set up a will trust with this type of trust in it. Also, a lifetime trust may be appropriate. So you can set up a trust now for any amount, and then that is already set up, and that can be a place where other forms of provision for that child is paid into during lifetime and in wills, not just yours as a parent, but other family members. You can pay income investments into the trust, assign pension benefits, life policies. So it's quite flexible and a really good thing to have, because we know that it is designed for protecting the child and their finances.
Yeah.
So I would say that there are some quite complex technicalities and tax implications associated with any trust. So I think if you're considering setting one up, then definitely come and get some expert advice, and we can talk you through everything you need to know about setting one up.
Thanks, Anne-Marie. That's really, really helpful. And if people want to find out a little bit more from you, how do they go about contacting you?
Okay, yes. So at Mogers Drewett, we have experts who can assist and advise in relation to all of these issues. You can contact us with the details at the end of this podcast, and also go onto our website at www.mogersdrewett.com for more details on how to contact us.
That's great. Thanks very much.
Thank you.
Your Money and Your Life podcast was brought to you courtesy of Mogers Drewett, solicitors and financial planners. On your side, at your side. Call 0800 533 5349 or visit mogersdrewett.com.